Good morning. Go ahead and ask everybody to take their seats. Thank you so much for braving the rain and being here this morning. My name is Lane Dilg. I'm the city attorney for the city of Santa Monica, and we very much appreciate you making it out this morning for the annual Landlord Tenant Forum hosted by the Rent Control Board, as well as the City Attorney's Office Consumer Protection Division. This morning's event is one of many things we do in Santa Monica that is unique and that is trend-setting. The city of Santa Monica, as you may know, for many years has been a leader in housing law. Our rent control law, we are one of 15 rent control jurisdictions within the state, has been a model and has generated debate across the state, across the region, and across the country. Recently reflected in state law, which will come into effect in 2020 and will cap rent increases for many units across California at 5% plus CPI. Similarly, our just cause eviction provisions in our charter have been a model and have led to considerable discussion and debate across the state, leading also to state law adopting similar provisions this year. Our tenant harassment ordinance, one of the first in the state, similarly has been a model, and our Consumer Protection Division, as well as our Code Enforcement Division, have been leaders in bringing enforcement actions under that law. The City Attorney's Office since 2017 has filed 11 complaints under our tenant harassment ordinance. Of those, 7 have been resolved favorably and 4 remain pending. We also, in the past 2 years, have adopted new protections for for teachers and school children living in rental units to ensure that they are not evicted for no cause during the school year, providing important stability for school children across our community. We also, in the past couple of years, have focused on voucher discrimination. In 2015, the city of Santa Monica drafted and adopted a law that prohibits discrimination based on source of income and discrimination against those who hold Section 8 vouchers. That law and the effective enforcement efforts of Deputy City Attorney Gary Rhodes and the entire Consumer Protection Division again have served as a model, first adopted in Los Angeles after Santa Monica, and then more recently now put into statewide effect. So the work that we do in our community and that we do in these rooms has statewide implications, and our discussions often generate things that are to come across our region and our state. We also, as one last example, recently obtained 2 published decisions from the U.S. Court of Appeals for the Ninth Circuit upholding our home sharing ordinance in the face of challenges from Airbnb, HomeAway.com, and others. Those decisions actually have national implications for the ability of local governments to regulate activities that are happening on the internet. The work that we do in this room, I want to be very clear, we all do together. We come together and we debate vigorously. As many of you know, and as many of you are a part of, we have an active and engaged citizenry, and that is what makes us so good. We have extremely dedicated and talented staff, and I will talk more about that in just a moment. But first, I want to pay tribute to all of you, to the tenants and landlords who come to meetings, who point out flaws in initial drafts, who debate the policy merits of whether we should adopt laws or not, who bring to the City Attorney's Office and to code enforcement complaints and concerns about things that are happening in your homes, to your family, to your friends, or from landlords to say, this is not realistic, this is not feasible, I can't deal with this. Those complaints, concerns, and particularly that public debate that happens in the Rent Control Board meetings and in the City Council meetings is what makes us so good. It is what makes Santa Monica such a unique place, and we appreciate you being here and being a part of that today. I want to thank the Rent Control Board, Tracy Condon, as well as her entire staff for being here today, for putting on this event. I also want to thank Code Enforcement for being here and talking through their role in all of this work. And I particularly want to thank the attorneys and staff of the Consumer Protection Division, Chief Deputy City Attorney Adam RADINSKY, Deputy City Attorney Gary Rhodes, Etta Sue, Autumn Rendels, and Andrew Braver. I want to thank our Consumer Affairs Specialist, Andrea Kavanaugh, as well as our Senior Law Enforcement Analyst, Paula Rockenstein, our investigator, Bridget Garay, and our Community Liaison, Johanna Rodriguez, and the heart and soul of the City Attorney's Office, Cindy Garcia, whose face I can't see, but we always appreciate seeing her smiling face every day. I want to thank them all, not just for being here today and for hosting this event, but for the way that they approach the work in this community. They're here because while they are very good at drafting laws and very good at enforcement, they're also committed to doing so in a way that serves everyone in the community. And one thing that has been very important to us is clarity about what the laws mean, engaging in the conversations, hearing the concerns, and making the laws better at every step. So that's what today is about. Again, we appreciate you being here. And the last thing that I will say before I hand it over to Adam is I want to take this opportunity just to talk for a moment about what Chief Deputy City Attorney Adam RADINSKY has meant to this community. This is Adam's last Landlord-Tenant Forum. The forum exists because of Adam. The Consumer Protection Division exists because of Adam. Adam has been a 30-year dedicated employee in this community. He has also been a statewide and a regional, and through all of the work he has done, really a national leader in consumer protection and fair housing work. And that is a tribute to who Adam is and the way that he approaches public service. He is an excellent litigator. As many of you know, he has drafted laws, he has refined those laws, and then he has defended those laws up to and including the California Supreme Court. He is an excellent litigator, but his heart is also truly in fair and effective development of the laws and education about those laws. And that's why we're here today, is to come together as a community, to all be in the room learning about these laws and learning about them from those who enforce them, often who drafted them, and who investigate them and can provide real clarity on where we are. So thank you so much for being here. Thank you for letting me speak for a few moments, and I will now turn it over to the expert. Adam, thank you so much.
Thank you all so much for coming. It's going to be a little weird because we have microphones, but you're not going to hear our voices amplified. So if it's ever too quiet, please let us know. We can speak up a little bit. We are going to have questions and answers. It's often people's favorite part of this event. You may have a burning question that you're really ready to ask. I ask that you just wait until the last portion for that. We're going to have a number of great speakers today and some hopefully good information for you. But if you can hold your questions till the end, that would be great. Also want to put in a plug for our fair housing calendars, which are available on the table here. They are free, they are beautiful, they are designed by, for many years now, local school children. There's a contest and there are winners. Everyone's a winner. But there's the number one winner whose design goes on the calendar. You will see those over on the table there. So thank you all for coming. Like Lane said, we absolutely depend on you for making this a dialogue, bringing us your problems and questions, and often, you know, the discussions that start in here can end up going to City Hall and end up changing the way things are. So you help us a lot by giving us, you know, your concerns and problems that you're facing. One last note is that we can't give you legal advice, as you probably know. We also can't go too deeply into an individual situation. We can talk off hours or back at City Hall. We can talk with you by phone about your individual situation, and we can break down at least what the law says. But here or there, we can't give you individual legal advice. So just kind of a preview on that. So again, thank you for being here. I will introduce now our first speaker, who has been at the city even a little bit longer than I have, which is Karen Evans with the Rent Control Board, an extremely knowledgeable information analyst. And Karen.
Okay. So I'm an information analyst with the Rent Control Board. I'm one of the 5 that you will call and talk to or come to the counter to talk to. So I'm here to discuss recent regulations that were adopted by the Rent Control Board. So the first thing that I will discuss is Regulation 4203 regarding sort of like the recalculation of rent decreases. Also, secondly, I'll be discussing Regulation 5100 through 5102, which is the expiration of removal permits that were granted to units or buildings. Thirdly, I will be discussing Regulation 2008, which is sort of like a definition of what a person is, and that rent control units should be rented to individuals / human beings. So, the first thing I'm going to discuss is Regulation 4203. So, this regulation was designed to compensate tenants for the intervening months during the rent decrease process. So, for all of you who are not really familiar with the rent decrease process, I'm going to discuss the process. First, a tenant has to give notice to the owner. And they give written notice. It could be by email, if that's how you normally communicate with the owner, or personally serve him, or by mail. So you're giving this written notice to the owner. You're telling the owner, this is what I want you to fix or restore. The owner has 30 days to fix or repair whatever is on the tenant's list. After 30 days, the tenant can come and schedule an appointment with the Rent Control Board and file their rent decrease petition. The petition goes through our staff and we assign a number, and then mediation is scheduled. After mediation, and if mediation is not successful, then there is a hearing. And then the hearing officer writes a decision that would become effective in 30 days. So what Regulation 4203 will address is those intervening months when the decrease petition is filed, and the first rent date after the petition is filed, and those little intervening months, because sometimes decrease petitions, they can go on for maybe 120 days or longer, depending on how complicated the decrease petition is. So, for example, if something is filed in May, the first rent due would be June, and then the decision is effective in September. So you got to take June, July, and August and add that to the schedule on the first month of the rent decrease schedule. So it's just designed just for tenants, to compensate tenants for those intervening months. Also, the regulation compensates an owner if they participate in mediation. So they will take like 1 month off, subtract that. So like if there's a $100 decrease, and they'll just subtract that month that they participated in the mediation. So also, there's a Regulation 4004, which gives the staff the opportunity to dismiss a petition if the owner does the repair before the scheduled hearing. So let's go on to Chapter 5, which is like putting in recirculation of Chapter 5, because Chapter 5 at one point was suspended. So now, since there's a recent California court ruling, appellate court ruling, saying that the Rent Control Board could assert jurisdiction over removed units or buildings that were granted removal permits that did not remove the units from the residential rental unit. They continued to rent it. They just remodeled the units, and they just went back into the rental business. And there's a few units out there that we've come across. So the charter under 1803T gives the authority of the board to grant removals in very limited circumstances. And these circumstances are if the owner is not making a fair return to retain a unit, or that the unit is uninhabitable and cannot be made habitable in an economically feasible manner, or if the owner wants to demolish rental units to build units that will be controlled and 15%, set aside 50% of the units to be made affordable to low-income tenants. Those are the very limited circumstances that the board will grant a removal. And we've had removals granted. For example, everybody, I know if you remember the Northridge earthquake, there were some buildings that were heavily damaged, severely damaged by the earthquake, and some buildings were granted these removals. Also, if code enforcement comes in and they find a bootleg unit and they deem that these units, they cannot be made habitable and they cannot be safe for human occupation. And we've had that to happen. And I just remember one case where an owner built a doghouse on top of a unit, or on top of the building. So what happened was they got the permit. It was supposed to be a doghouse, but they just started making these little additions, putting in a bathroom, putting in a little kitchenette. So eventually, down the line, they got rented. So when rent control began in '79, they registered that unit with this on our books. So code enforcement got wind of this, and they cited the owner and said, you know, you can't have this. It was supposed to be a doghouse, but now you have it for human occupation. The square footage was only 223, and he found someone that was willing to rent this, and we called it the doghouse penthouse. So the owner had to get a removal because it was a registered rental unit. So we granted the removal because there's no way, you know, he could keep this unit. So that's why there are some removals that are granted. There's some removals that the owner never did remove the unit from the rental market, and they just rehabbed it or remodeled it and went right back into the business. So those are the units or the buildings that we're going to address and bring back. And what this regulation, Chapter 5, is going to deal with is that if you get the removal, and if you ever rent it, it's going to come back under rent control. Also, there is an expiration now, just like there's expiration on anything. You go in the grocery store and there's expiration on products. There's going to be expiration on removals that were granted to properties. So again, under this regulation, the expiration period is this: for these removals that were granted before October 15, 2018, if they didn't act upon it by October 15, 2019, those removals are expired. They're back under rent control. Also, going forward, if a removal is granted and you don't act upon it within 90 days, the removal has expired. And also for property owners that want to demolish buildings to build affordable units, if they don't act upon it within 2 years, then it's expired. So that's pretty much Chapter 5 deals with this expiration of removal permits. And it's very limited. There's not many buildings that we're going to deal with, but again, we're going to bring those buildings back that did not demolish, or they're now renting these same units. And lastly, we're going to go into Regulation 2008, which kind of addresses the issue of owners renting to corporations. And the whole goal of this is that we want these units to be rented to human beings for the long-term period, and just to stabilize the community, and not to have it being rented to corporations and the corporations rent to just visitors. So that was the whole intent of this regulation. And if you want to rent to a corporation, you have to get a removal. And again, removals are only granted in very limited circumstances. So that's it for our recent adoptions of regulations. And so I'm going to introduce Daniel Costello. He's the manager of the public information. Our esteemed manager is coming up.
Thank you, Karen, and good morning, everyone. So I'm really here to make an announcement about something that we think is kind of exciting. Imagine if you're a property owner and you have to register a tenancy. And imagine if you could do that on your cell phone. So we have been working to introduce a new system that would allow you to do that and to file forms with us and to be able to view the documents in our records all through a web portal. So this is something that I think has been long in coming. Right now, with most forms, you have to file those things on paper with a signature, and that's just not the modern way of doing things. So we're very excited about this new system that we're developing, and we think it's going to give you a clearer vision of the property information that we have, and tenants will be able to use it to file petitions, like Karen mentioned, the decrease petition, and we can communicate with you in the ways that you want to communicate. So if you want to say, communicate with me by email, then we can do that. If you want to stay with regular mail, we can do that. But this system is going to give us a lot of new opportunities. So we're calling it Rent 2020, and that's both the year and I think some clarity of vision. This is something I think is really going to be great for you. Right now, we have a rent database that is very dated. It's written in COBOL, and it's nearly 30 years old, and it's very limited. So we think that there are lots of opportunities. I don't know if any of you have ever gotten a printout from the rent database, but because of the limitations, we often have things that are coded. So a parking type might be a 4, and without explanation, you don't know what that means. But we're going to try to present information in very plain language for you with this new system. Another part of it will be to offer many years of documents that we have in our document management system. So initially, we're going to be offering about 15 years of documents. So you will be able to go to a web portal, and you can search by address, and you can filter by document type or year, and you'll be able to see what we see in our records. And I think that'll be a lot of transparency that will be helpful, and you can do your own research about what's in rent control records. This system also is going to simplify some of the processes that we have. We have an online tenancy registration form that you can use today, and that's a lot better than the paper forms that we had. But we're going to simplify that even more so that you won't have to provide as much information. Once you're registered with the system, we're going to know who you are, and should make things a lot easier for you. So what is the next step? So the way to get started with this is to send us an email. So we've set up a mailbox. It's rent2020@smgov.net. And if you can't remember that, there's a newsletter on the table over there, and it's got that email address for you. But what we'd like you to do is just to send us an email, and if you're a property owner, let us know which properties you own, or if you're a manager, which properties you manage. And then when we launch the system, which we're expecting to do in early spring, then we'll set you up so that you'll be able to see information that's specific to your properties. For those of you who do sign up sooner, before we go live with the general launch of Rent 2020, we will provide you early access to the document portal. So you'll be able to go in and look at documents before the general go live. We will be sending a mailer sometime in the new year just to remind you to sign up if you haven't done that. We understand that this is going to be a new opportunity for people, and there's going to be some learning. So we would be happy to meet with any of your organizations. If you're a large property manager, say we can come and do some training with you, or one of the apartment owners associations, we'd be happy to come and give a presentation to you about the new system. So stay tuned, but we're really excited to introduce this to you. So hope you enjoy it.
Thank you, Dan. So As you all know, Santa Monica has been in the center of controversy over the landlord-tenant law since the city passed rent control more than 40 years ago. And depending on what your opinions are, the city is either famous or notorious for influencing other laws. As Lane said, a lot of times ideas that start here can spread to the statewide or even national level. And this past year is no exception. There's been a lot going on in Sacramento that affects all of us here. And I want to introduce Andrea Kavanaugh, who most of you know. Andrea is our consumer specialist in the office, and she works tirelessly on these issues. She's also the driving force behind this event and many of our public events where people can come out and get information and ask questions. So please help me in welcoming Andrea Kavanaugh.
Hi, good morning, everyone. I want to thank everyone for coming out, especially in the rain. You know, that's a license to stay home in Southern California, so you get extra points for coming out today. Thanks for being here, and thanks to everyone who makes this event possible. There's three developments, landlord-tenant law, that we're going to focus on today, having to do with statewide rent control, and having to do with electric vehicle hookups in rental properties, and about a notice requirement for a rent increase. Those are the three topics. So the first one is AB 1482. Has everybody heard about statewide rent control? That's a hot topic. So AB 1482 creates rent controls in cities and counties that didn't have them already, and it expands them in cities and counties that do. So it applies to all rental units with a few exceptions. So statewide rent control puts a cap on annual rent increases of 5% plus inflation, which is defined as the Consumer Price Index, or 10%, whichever is less. So the maximum amount a rent can increase is 10% per year. It could come in two increases, a maximum of two increases in a 12-month period. And this law takes effect January 1st, 2020, and applies to all tenancies of 12 months or more. And as far as the jurisdictions like Santa Monica that already have rent control, if the amount of the allowed increase is less than the amount allowed under state law, then the local law will prevail. So for most properties in Santa Monica that fall under rent control, the state law is not going to affect them. Particularly for properties with 4 or more units. There are some exemptions from the state law, and those are properties that were issued a certificate of occupancy within the last 15 years. And that's a rolling date. So a property that was issued a certificate of occupancy on January 1st, 2005 will be exempt when the law goes into effect in January 2020, but as the time goes by, that exemption is going to fall off. So it's incumbent on the owners to know when the certificate of occupancy was issued, because that's going to determine largely whether the property falls under rent control. Another exemption in the state law is single-family homes and condominiums, but the only ones that are exempt are those that are owned by natural persons or family trusts. So single-family homes and condos that are owned by corporations, LLCs, real estate trusts are not exempt. And another exemption is duplexes that are occupied by the owner at the start of the tenancy of the tenant. There's also a provision for a rollback in the rent increase. So an owner that instituted a rent increase on or after March 15th of 2019, if it exceeds the amount allowed under the state law, it's going to roll back to the allowed amount on January 1st. And there's also, it also extends just cause eviction protection to the tenants that are covered under rent control. It's not as much of an issue in Santa Monica because our multi-unit properties, even those that are not under rent control, those tenants already have just cause eviction protection. So, and there's also some pretty strict notice requirements that are really important to take note of if you're a landlord. If the property falls under rent control, you're required to notify the tenants in writing. that the property falls under rent control and under the statewide law. So the deadlines for that, for any tenancy that exists prior to July 1st, 2020, your landlords are required to notify the tenants in writing by August 1st, 2020, that the property falls under rent control. It can be provided as a written notice or that's signed by the tenant and they're given a copy, or it can be included in the rental agreement. Landlords who want to claim an exemption from rent control are also required to give a notice to the tenants. And that's, again, for tenancies that start before July 1st, 2020. It needs to be provided in the rental agreement. And definitely for tenancies that start after July 1st, 2020, it needs to be included in the rental agreement. If the landlord does not provide that notice to the tenants, the exemption does not exist. And so if the landlord does not provide that notice to the tenant, then an otherwise exempt unit will fall under rent control, and the tenant will have just cause eviction protection. And you guys all know what just cause eviction is, right? So this is no fault eviction. Tenants can still be evicted for cause. There's a number of reasons that are outlined in the civil code, but there are a number of reasons. There's no fault eviction, which falls under the Ellis Act, or owner occupancy, or demolition, or uninhabitability as determined by a government agency.
Excuse me, your voice keeps trailing off at the end of your sentence.
Okay, I'll work on that, sorry. So the AB 1482 is enforced by the courts. It's not enforced by our rent control agency. They're not able to answer questions about it. Our office, the city attorney's office, we are answering questions about the law as we can. So if you have specific questions about a property, you're welcome to call our office, the city attorney's office, and we will answer the questions as we can. We don't give legal advice, as Adam said, but we are happy to tell you what we can about the law. There's also apparently a hotline set up, I think by the author of the bill. So if anyone is interested in taking down this number, it is 888-428-7615. So I'm sure there are a lot of questions about the statewide rent control. It's a fairly new development. But it's incumbent on both, I think, landlords and tenants to educate themselves about it. It's certainly not a simple law. So we're happy, the city attorney's office is happy to help where we can to clarify the law. Another development in state law has to do with noticing requirements for rent increases. So the existing law was that a rent increase of 10% or less required a 30-day written notice to the tenants, and that is still the case. A new state law has expanded the notice requirement for an increase of more than 10% is going to require a 90-day notice to the tenants rather than a 60-day notice. And if that doesn't apply to most of our rental properties that fall under rent control, but it certainly applies to uncontrolled units, and it also applies to, say, a rent-controlled unit where the owner has not passed through the increase for a number of years, and so it may result in an increase of more than 10%. So the tenants are now entitled to a 90-day notice rather than a 60-day for that. And the third development is about electric vehicle hookups, which are becoming, more and more of an issue and more of a desire as more people buy electric cars. So a state law that went into effect in the beginning of 2018 required landlords to allow tenants to install electric vehicle hookups in their assigned parking space at their own expense. There was an exemption for that, and that one of the exemptions was for rent-controlled properties, but that exemption has been removed. And there was also a requirement that the tenant purchase liability insurance of $1 million. And that requirement has been removed as long as the tenant has a device that is certified by a nationally recognized testing lab and is installed by a licensed electrician. If those two factors are present, then the tenant is not required to have any insurance at all. If none of those factors are present, and I'm not sure why you would want to do that, the tenant is required to have a personal liability policy that doesn't exceed 10 times the amount of the annual rent. There are still some exceptions to this rule if there are fewer than 5 parking spaces on the property, or if already more than 10% of the spaces are designated EV, then the landlord's not required to allow it. If the tenant doesn't already have an assigned parking space, or I'm sorry, if the parking is not included in the lease or the rental agreement, then the landlord's not required to allow it. And again, the tenants pay for this. They're required to pay for all of the expenses as well as the permits. They're required to pay for the removal at the time that their tenancy ends. And they're required to comply with all local and state laws as far as the requirements for installing it. So those are the main updates in state landlord-tenant law that we are aware of. I'm sure there are lots more. It's a very dynamic area of law, but those are the ones we're getting a lot of questions about, particularly statewide rent control. So again, if you have questions, specific questions about it, you're welcome to call our office and talk to us about it. Thanks.
Thank you, Andrea. Well, the city has a team of code enforcement officers that has grown in recent years, and they do an amazing job. They enforce all different laws, many of which you may not have even heard of throughout the municipal code, keeping businesses above board and following the law. One of the hardest areas they work in has to do with construction, and especially construction in residential buildings. As you probably know, one of the toughest areas for conflicts to come up between owners and tenants is when there is construction that the owner is doing that may disrupt the daily lives of tenants. There are quite a few laws that come into play as far as how owners have to deal with those situations. And possibly the toughest of all that of the many conflicts code enforcement deals with is when tenants feel that an owner is intentionally using construction-related problems or situations to harass them, to make life difficult, to hope that maybe they will leave. There are also potential buyout offers, and as you may know, there's a whole law that the city has passed about how those have to be done when there's buyout offers. So there's a whole lot going on, and I want to introduce one of our great city employees, Armando Rangel, who's the supervisor of code enforcement officers, who's going to give you some information about harassment in construction situations. Armando.
Thank you. Thank you, Adam. Again, my name is Armando Rangel. A little bit about myself before we get into substandard housing and construction-related tenant harassment. Again, my name is Armando Rangel. I'm the code enforcement supervisor for the city here. I've been here for approximately 15 years, and I come, prior to working for this lovely city, I worked for the city of Beverly Hills. In all, I've got about a little over 20 years of experience. I'll raise my voice so you can all hear, sorry. A little bit about the Code Enforcement Division. The Code Enforcement Division is comprised of 21 staff members. We have a manager, 3 supervisors, a lead officer, 13 code enforcement officers, and 4 administrative staff members. And our office investigates a wide range of complaints, particularly pertaining to building and safety, construction-related conditions, substandard conditions, zoning violations, public nuisances, public works violations, short-term rentals, and as of May 2018, tenant harassment related to construction impacts and substandard conditions. And we'll talk a little bit about that. A little bit of background information, sort of how we got involved. Historically, and until May of 2018, complaints were investigated by the city attorney's office, Adam RADINSKY and their group. And what we realized was that code enforcement officers often happened upon potential tenant harassment related issues while investigating complaints, their normal day-to-day complaints, particularly in substandard housing conditions and construction related impacts. So what we figured was that with a little training, Code enforcement officers would be able they'll be able to identify signs of harassment during the routine inspections and engage with landlords and tenants regarding those issues. Code enforcement officers would be able to educate landlords and tenants, investigate potential tenant harassment violations, and take appropriate enforcement action when needed. So upon confirming a tenant harassment violation related to construction or substandard housing violations, code enforcement officers would have the ability and the authority to take appropriate enforcement action, including, but not limited to, the issuance of an administrative citation which carries a fine amount of up to $1,000. So in May of 2018, after receiving tenant harassment training provided by our partners in the City Attorney's Office, our Code Enforcement Division began investigating tenant harassment complaints. And we'll get into a little bit about what the code says here in a second. But tenant harassment complaints that the code enforcement officers investigate, again, are specifically in situations pertaining to substandard conditions and construction impacts where landlords were failing to perform required repairs and maintenance. It's important to note that code enforcement's primary focus is on the substandard condition or the construction impacts related to the alleged harassment. A code enforcement officer will take enforcement action if during their investigation into the substandard condition, the officer finds evidence to support that a landlord acted in bad faith and violated the tenant harassment ordinance. We'll get a little bit into the bad faith portion in a second. So let's take a closer look at tenant harassment, specifically substandard housing and construction-related tenant harassment. The code says no landlord shall, with respects to property used as a rental housing unit, do any of the following in bad faith: interrupt, terminate, or fail to provide housing services required by contract or state, county, or local law or health and safety laws. This includes illegal lockouts. For example, when a unit has been rendered uninhabitable, necessitating the tenants of the unit to temporarily relocate, the tenants have the right to very limited access into their units to retrieve personal belongings. If a landlord changes the locks and does not provide the tenant with the key or reasonable access, the landlord could be in violation of the tenant harassment ordinance. Housing services has a broad definition, and it's defined in the municipal code. And for those that are taking notes, it's section 4.56.010 of the municipal code. The code also states that landlords cannot fail to perform repairs and maintenance. Again, the code says, cannot fail to perform repairs and maintenance required by contract or by state, county, or local housing, health, and safety laws. Landlords cannot refuse to make repairs that are required by law. For example, dwelling units require to have a functioning bathroom, a functioning kitchen sink, hot and cold running water, and adequate heating facilities, just to name a few. Landlords who fail to perform these repairs in bad faith are in violation of the tenant harassment ordinance and subject to enforcement action. In addition, landlords cannot fail to exercise due diligence in completing repairs and maintenance once undertaken. This includes habitability determinations. So landlords must work diligently to make repairs and cannot unreasonably delay the repairs required by law. A landlord who willfully and maliciously fails to make required repairs is in violation of the tenant harassment ordinance and subject to immediate enforcement action. So that's the unreasonableness and the willful and maliciously failing to make repairs. Illegal buyouts. Illegal buyouts was mentioned by Adam RADINSKY here earlier. So code enforcement officers also investigate cases pertaining to illegal buyouts in situations where ongoing construction or substandard conditions exist. The code states, no landlord shall do the following in bad faith: influence or attempt to influence a tenant to vacate a rental housing unit through fraud, intimidation, or coercion. So prior to making a buyout offer, the landlords must provide each tenant in that rental housing unit written disclosures on a form developed and authorized by the rent board. A landlord who fails to comply with the buyout process that is set forth in the code, or influences a tenant to vacate a rental housing unit through fraud, intimidation, or coercion, is in violation of the tenant harassment ordinance and subject to enforcement action. So what is bad faith? We talked a lot about bad faith, bad faith, bad faith. It's defined in the municipal code as an intent to vex, annoy, harass, provoke, or injure another person. This includes, but is not limited to, the intent of a property owner or manager to induce a tenant to vacate a rental housing unit through unlawful conduct. It's the same as malicious or with malice. And we, in our Code Enforcement Division, we investigate our cases very thoroughly. We interview parties, we interview witnesses, and we attempt to attain all the facts. It is an intense fact-finding investigation. The burden of proof is on the city. And in order to enforce the tenant harassment ordinance, we must be able to prove at minimum that more likely than not, a landlord acted in bad faith. So a little bit about the enforcement. The enforcement in terms of the penalties here. Code Enforcement Division works in collaboration with our partners in the City Attorney's Office. We hold the right to refer cases to the City Attorney in lieu of, or in addition to, an administrative citation. Other enforcement remedies include criminal prosecution or civil prosecution. With respects to the administrative fines that our Code Enforcement Office issues, there's 3 different code sections that I'll list for those that are taking notes. But disruption of housing services carries a $500 administrative citation fine amount. That section is 4.27.010. Tenant harassment, the prohibition section, carries a fine amount of $1,000, and this is with respects to an administrative citation, $1,000. That code section is 4.56.020. And illegal buyout offers carries a fine amount of $1,000, and that section is 4.56.050. And how to report a complaint, a tenant harassment complaint to code enforcement if you have ongoing substandard conditions or construction impacts. You can report complaints to us online via Santa Monica Works, formerly known as Government Outreach, by email. We can email us at code.enforcement@smgov.net. You can come in person into the building and safety counter at City Hall and ask our counter staff to provide you with a complaint form. Or you can call us by phone at 310-458-4984, and we will direct you to or provide you with a complaint form. Complaints must be in writing. Like I've stated, there's a lot of fact-finding here. There's a lot of information that we're going to need from you, the person who's complaining about a situation, and so it needs to be in writing. It needs to be on a form that we provide you, and we will investigate your concern. Yes, it is 310-458-4984.
On the handout,
Yes.
is there a dash between code enforcement, like
In the email?
Yeah.
It's a period. Code.enforcement.
Thank you.
Yes. Thank you.
Thanks, Armando. So before we take a short break and get to your questions, I want to go over a couple developments in local law. As Lane said earlier, Santa Monica is always looking to improve the law and make things more fair for our community. So there was a law that passed a couple years ago, but we've been working very actively in our office enforcing it, which is the source of income discrimination that, as Lane also said, has now spread to the statewide level. But as of now, just to remind everybody, I think we mentioned this last year, but under local and state law, it is against the law for a property owner to discriminate against a tenant or applicant based on their source of income. What this most often means in everyday language is Section 8. the Section 8 program, Section 8 voucher, an owner cannot refuse to accept it. Now, there is a difference potentially depending on the rent level. A landlord is not required to accept a lower rent because of the source of income if the Section 8 contract is for a lower amount. But they are required to accept vouchers that are equal to the going rent for that unit. In our office, thanks to the hard work of Andrea Kavanaugh and Gary Rhodes and others over the past couple of years, we have gotten complaints from tenants and applicants and investigated more than a dozen cases and persuaded the owners by educating them about the law and their requirements and, if necessary, threatening them with litigation. But we have gotten very successful results in more than a dozen cases where a tenant was facing potentially losing their home. There's one woman who had lived in Santa Monica for more than 50 years. And she was initially blocked from applying at a large apartment building when management told her, sorry, we don't take Section 8. The woman came to our office and we got them straightened out, and she's now living in the home there. There was a severely disabled tenant with traumatic brain injury who was in an apartment, and his current landlord told him that he couldn't use his new Section 8 voucher. So he had just gotten a new voucher and was told that he couldn't use it. Now, this gentleman was spending more than 90% of his income on rent. So he was already very hard hit with his housing costs, but the owner was required to accept the Section 8 voucher, which was a huge help to him. There was a low-income woman who was looking for a home in Santa Monica and thought she finally had found the perfect apartment and the rent, but that management company also told her, sorry, we don't take Section 8. We got that straightened out, and she got the unit. There was another case where a landlord had been in the Section 8 program and decided that they no longer wanted to continue. And so they served 90-day notices to vacate on 3 different of their Section 8 tenants, saying they no longer wanted to participate. That also was a violation of the law, and our office helped to get that situation straightened out. There was also an interesting twist on this where we had a complaint from a tenant that the landlord had said they were willing to accept the Section 8 voucher, but they had income requirements that the tenant also had to meet in order to rent the unit. Those requirements would in effect have invalidated some of those, or disqualified some tenants from renting. That also was not allowed because it in effect amounted to discrimination against the tenants for their source of income. So another question we sometimes get is about who's paying, who's writing the check. Can somebody write a check for somebody else? If I have a Section 8 a payment that comes from some government agency, some owners are worried about accepting a check from somebody other than the named tenant. And the fact is that state and local law require landlords to accept rent payments from third parties if there's a written statement that that party is not attempting to create a new tenancy. And that's, sorry? Yeah, you need to have a written statement from the person writing the check saying, I'm not trying to become a tenant. There's a California Civil Code has a section on that. So there's a lot of confusion about that over the years about who can write a check. So if you're a property owner and your tenant wants to give you a check as all or part of their rent, such as a Section 8 check, they are allowed to do that as long as there's a written clarification that somebody's not trying to get in the back door and create a new tenancy. It's also against the law to use discriminatory language in ads. Not only other kinds of discrimination, such as age or religion or race or things like that, but also you can't discriminate against source of income even in sort of implied ways in an ad. You can't say something like, we don't take Section 8, obviously, but also it's against the law to make it sound like a unit's not available when it really is available, depending on how the person is paying. You can't discriminate in any way on the basis of source of income. And just to remind everybody, this also applies to the harassment that Armando talked about, but a landlord, as defined in the law, means not only the actual property owner, which could be an individual or an LLC or a corporation, it also applies to managers, it also applies to people who collect rent, who work on behalf of the landlord as any kind of employee or agent. All those people are potentially liable under the law for discrimination, harassment, and these other issues. And if anyone has questions, whether it be an owner, a manager, a renter, please call the city attorney's office. We do answer questions about this kind of discrimination as well as other fair housing and harassment issues. One other law I just want to mention is just a couple months ago, the city council did pass a new change to the relocation law, and we sort of joke in City Hall that there's been a lot of changes to the relocation law in the past 20 years. It is a very complicated and difficult area of landlord-tenant relations. And there's two different situations. There's what we call temporary and permanent. Temporary relocation is where there's an issue such as uninhabitable unit, there's a problem, maybe there's fumigation for termites or something much more serious. But it's something that requires people to get out because it's not safe or it's not legal for them to be there. But they come back, okay? Permanent relocation is when a tenancy is terminated, whether it's by owner occupancy, ellising a unit, removal from rent control. Those are the most common reasons. But I want to just mention a couple of changes. These are kind of minor changes, but they may affect your situation. Just a couple months ago in September, the City Council expanded permanent relocation payments to include units that are removed from rent control under the owner occupancy of duplexes and triplexes. So those are also now, if you're an owner and you owner occupy a duplex or a triplex and the tenants are forced to leave, they are now also entitled to permanent relocation. And the permanent relocation law has a number of requirements, including you have to put the funds in escrow for the tenant until the process is done, so they'll be sure to get their money. These new areas also require escrow. The amounts also are adjusted each year as the City Council looks at how much it actually costs to move and get into a new place. So those are the two local developments I just wanted to mention to you all. We are going to take a short break now for folks to use the restroom and get some refreshments. Please come back promptly. I know you're all looking forward to asking your burning questions, and we'll be here to answer them. We'll see you in a few minutes. Okay, we're gonna do questions and answers. So I ask you to, we will answer questions in just a moment. So what we're gonna do is, Karen, Armando, Andrea, and myself are up here, and between the four of us, hopefully we can help to answer most of your questions. But it does take a village, and at many of these meetings, some of our best answers have come from out there. So I know we do have some other city staff that are here as well, and we will all certainly do our best to answer your questions. So again, we can't go too deeply into your specific personal situations to give you advice or specific answers, but we can try to address what the law says. And I'll remind my friends up here that because we only have one microphone, you guys won't have a mic, so we are going to repeat your questions for the microphone. So it doesn't mean we didn't hear you, it just means we need to repeat it so that it can go on City TV. So, for our first question, yes.
My question is the code enforcement, and it's about Airbnb-ing in the buildings in Santa Monica. It's not clear to me how the law is really being enforced. I understand that the tenant has to live, a human being who has the rental agreement has to live in the unit, but how are you actually checking on that, and what is the process? Because the experience in our building is that code enforcement comes, They know there's a problem. They say they can't get in the unit to inspect it. So what recourse do we have when we know that the tenant on the lease is not living there?
So I'll just recap real quick. With the question for Armando was Airbnb, and if there are tenants in a building that may be renting out the unit to people who come and go, there's a requirement, many of you may know, that in order to do the Airbnb type arrangement, you have to live in that unit and rent out a part of it. So she's asking, what can people do if they suspect violations of those rules, and what does code enforcement do?
Thank you. It's a good question. In our code enforcement division, we have 2 people specifically assigned and dedicated to Airbnbs, vacation rentals, and home sharing. So I think what you're describing is a home sharing situation where there's a tenant who may or may not live in the unit and they're renting it. In situations like that, you can contact our office, submit a concern or a complaint.
Excuse me,
Yes.
it's not home sharing. There are people coming and going every day.
Oh, okay. So
It's Airbnb.
you can call
2 or 3 days.
in and out, in and out. So she says, she clarified that it's not home sharing. There's people coming in and out every day, so it's more of a vacation rental. So you can submit the complaint to the code enforcement office, to our division. Our officers will investigate. They'll look for the advertisement. They'll look for the ads. Whatever information you can provide us is very helpful in terms of maybe if you see something like it's every Friday, or it's on the weekends, or it's whatever information you can provide is very helpful. Log boxes on the handrail, exactly. Yeah, things like that. And the officers will investigate, gather the information that they need in order to take the appropriate enforcement action. And oftentimes they need the help of the citizens to let them know when they're coming and going, or who they think is doing what. But together, hopefully, we can address the issue.
Okay, yeah, the gentleman in back there.
I have a somewhat related question. On the Santa Monica regulations, if you have a lease that has 2 bedrooms and one of the tenants moves out, then the remaining tenant can swap a roommate, and in that situation, it would be more of home sharing. So if you have a situation where the remaining tenant is subleasing the other bedroom and they're subleasing it for more than the current maximum allowable rent, is that permitted action under the code to really circumvent the MAR through a sublease?
So the question is, if there's a 2-bedroom apartment with 2 tenants and one tenant moves out, can the remaining tenant sublease the 2nd bedroom for an amount greater that puts the total amount greater than the maximum allowable rent, which sounds like a rent control question, Karen?
So yes, we have situations that have arisen with this type of situation, but the MAR is what it is, and I'm assuming that this is a rent-controlled unit. So the MAR is what it is. It's for the tenant of record, and it sets the rent. And I don't know if it's a pre-99 or post-99 tenant, but the rent is pretty much set. So if they are charging more than the MAR, then the one of the tenants can file an excess rent complaint with the board. And that's how we deal with these types of situations in an excess rent complaint.
I guess, but what about as the landlord, you're having your tenant basically using the other bedroom as their own rent control property, and it's not subject to rent control because they can charge whatever they want?
Well, look, well, he's talking about subtenants, and the subtenant or the master tenant is charging, that's what I assume, the master tenant is charging more than the MAR to the subtenant. Well, just like the owner can't charge more than a MAR, the master tenant can't just arbitrarily circumvent the law by charging the subtenant more than what the MAR is. So again, the subtenant who is paying more than a MAR can come to the board and file a complaint for excess rent to get the money back, the overpayment of rent.
Oh, I see. So there's really nothing that could be done on the landlord side. We just have to kind of allow this activity to happen.
Well, Andrea knows that 1482 has a standalone paragraph that deals, and code enforcement read it, 1482, that deals specifically with the subtenant who attempts to charge a sum of money greater than the established rent. Andrea knows that. It's illegal under 1482.
But we're talking about a rent control remedy.
Right.
I'm just talking about the rent control remedy, and this has happened before, where the master tenant is charging more than a MAR to the subtenant, and it's the subtenant that could come forward and they can file a complaint against that master tenant, and the owner is out of the situation because the master tenant is paying the owner the MAR, but the master tenant may not be paying rent at all. He may be charging over the MAR to the subtenant. So that is illegal.
I'm just saying, under the state law, it's addressed and it's unlawful and it's completely illegal. Under no circumstances can the rent be greater than the established rent, whether it's controlled or not controlled. It's in the state law. Thank you, Al.
Basis for eviction. Well, there was in addition to the question, there was a comment that may not have been picked up, but just to be clear, it is unlawful to collect more rent than the maximum allowable rent control. So if the main tenant is collecting an amount higher that puts it over the MAR, then that's illegal. And it's a tougher question on how that's enforced and who can enforce that. If the new subtenant finds out that they're being overcharged, they definitely have remedies and can come forward. It's less clear, I think, exactly what the owner can do and how they would prove it and so forth. So maybe one question is, does the owner have a remedy under rent control if they find out somebody is subletting for over the MAR?
Well, for the owner, I mean, we do have just causes for eviction, and you have to frame it within the just causes for eviction. I don't know if it's nuisance or they're violating the rental agreement. So it's really up to your attorney to address the issue of any kind of eviction. But we're talking about remedies for the subtenant. And if they're being charged over the MAR, then they do have a remedy with rent control, which is an excess rent complaint.
That's a good reminder that with a lot of these problems of complaints about behavior by a tenant that might violate their lease or violate the law, the owner always has the potential remedy of taking legal measures against the tenant if they're breaking their lease or if they're breaking the law. Yes, sir.
Was the assumption of that last question correct, that if there are two named people on a lease and one of them moves out, that it's still a valid lease if I just get another roommate?
So the question is, if there are two tenants on a lease, one moves out, is it still considered the same lease for the landlord's purposes, right, or for rent control purposes?
Yeah, is it okay to just get another roommate because there were two people on my lease and one moved out?
The question is it okay to just get another roommate? And it partly depends on what the lease says. You know, so some leases are specific.
It says only for the two people named on this lease.
Right. So if the lease says it's just for the two people that are named there, then my understanding is the new person would have to apply.
That
But
wasn't the assumption of your question.
Yeah, they have, my understanding is they have the right to apply, and you can't just you have to review it and approve it in good faith, because they do have the right to swap roommates.
so there is now another interesting question that we have dealt with, which is if there's a vacant room and new people are applying to be the roommate, what are the owner's duties? And one of the general rules is that the owner has to be reasonable and consider people fairly. But did you want to add something, Karen?
I'll just add if it's a rent control unit, we have under the regulation that a tenant can replace on a one-for-one basis, provided that it's in the rental agreement. So there's two people in the rental agreement, one person leaves, then they can replace on a one-for-one basis. They have to give written notice to the owner, and the owner cannot deny the request unless there's some issues. They can't really deny the person the request for a roommate unless there's, again, reasons. Now, if it's a post-99 tenant and they came in with two people and the owner unreasonably denies the request for a roommate, the tenant can come forward and petition for a rent decrease. So we do have that for post-99 tenants. Pre-99 tenants is a little different because you got to prove back in April 10, 1978 that there was two people living in the unit in order to go forward with a rent decrease petition.
Can I just say one thing to help him? If you had two people living in your apartment prior to 1979, you can have a roommate. And you can look it up in the book. You can have two people living there, They could be your overnight guest, and they could be your roommate. They're not your tenant, they're a roommate. And that's a law, because I checked it in the building I live in, and there were always 2 people living in my apartment. And when my son passed away, other friends stayed there, and the owner can't do anything.
Right, so we're just talking about a remedy for a
Okay,
tenant.
I'm just trying to help you.
Right, right. So that's the remedy for a tenant, pre-99 tenant.
Okay, thank you. Yes, sir.
I think there's a state law that says something about how often a landlord has to repaint an apartment, replace the rug, stuff like that. I wonder if you knew anything about that.
So the question is about California state law about how often carpeting and painting have to be replaced, things like that. Do you guys have general information you give out on that? I mean, it's a function of state law, and yes, there are laws about it. I don't know offhand what the numbers are, but.
The question was about whether there are laws to replace the carpeting and paint and so forth. And as I understand it, there are no laws governing that. The State Department of Consumer Affairs has some guidelines about how often, what the expected lifespan of things like carpet and paint are, but there's no requirement. However, there are some code enforcement requirements about certain aspects of that. Pardon? Okay. What if the paint is peeling and the carpet is torn? And so Armando knows more about this than I. But there's no actual requirement saying you have to replace the carpet in X number of years or the paint.
Correct. There's no number of years determined, but if the paint is chipping, then that's something that either we in code enforcement or LA County Health Department can help you address. With respects to the carpet, if the carpet is torn or deteriorated, the LA County Health Department can also address those issues.
Okay. Yes, sir.
The question on Section 8, we have 3 elderly existing tenants who we want to apply for Section 8 and they refuse to do so. What help can different groups in the city give to encouraging and otherwise somehow arbitrarily applying for the Section 8 that they otherwise very well might qualify for?
So this is a twist. This is
intimidated by the process.
This is an owner who wants to encourage 3 tenants to apply for Section 8. They don't want to. They might need encouragement, and he's asking what are the resources available to help the owner in that situation. It's a fair question. You certainly can't force somebody to enter into this kind of program if they don't want to, and if they're able to meet their rent and they're following their lease and everything, there may not be a whole lot you can do to try to get them to change other than have a conversation.
I think there should be some effort by the city to push forward with that. It's in the interest of the city to have some very, very low rents increase to protect the overall buildings over time and to help tenants otherwise who may not realize that they really do qualify for either on their hand a lower rent, the other
Sure.
hand higher rent to the landlord.
So he's saying there should be something the city can do to help encourage people, and I know there is, of course, a waiting list for the vouchers and for the program, for units, I should say. And so we do have a department, our housing division for the city works hard to, administer this and make sure people get what they're asking for. But it's a fair concern about putting the word out.
I'd like to follow up on
yes.
this question. I know other people, but now you have the maximum allowable rent, or landlords saying, well, we want $3,000 or $3,500, but yet the voucher is only for $1,900. If people have vouchers, it's discouraged because they get disqualified because the landlord wants more than what the voucher is worth. And the city isn't doing anything to either, like he had mentioned, have a mandate. If you're not going to encourage it, landlords aren't going to take it. So therefore, it's going to clog the whole system with people trying to wait to get into affordable housing. Now the city has a deed restriction in place because there's so many people desperate to stay in the community that I got priced out 15 years ago. I still don't live or wasn't able to move back into this community, all because of Costa Hawkins back in 2005. That makes me very bitter and resentful. Right. So you should do something to allow people who have a voucher or want to get into housing to basically not be forced or prevented from moving back into the community.
So the comment was about maximum allowable rents that are far above the amount that somebody's voucher might be, so they still can't afford to rent a particular unit even when they have the Section 8 voucher. It's a valid concern. Yes, sir.
If the rental criteria that we use is for the applicant to make 2.5 times the amount of the rent, how do you apply to a Section 8 tenant?
Okay, that's a very good question. So the question is, if you have a normal rule for applicants that to rent an apartment, your income has to be 2.5 times the amount of the rent. But someone who comes in with a Section 8 voucher, they might have much lower income, if any, and how do you handle that with the Section 8 voucher? And so I think one immediate thought is that you can't discriminate against the Section 8 voucher. So if your rule has the effect of discouraging or disqualifying people who might have much lower incomes and have another source of income, I think you might need to adjust that rule. Yeah, Andrea.
So we did have a complaint. The question is about income requirements and how that relates to accepting a tenant, a Section 8 voucher. We did have a complaint from a tenant who the landlord said they were willing to accept the voucher, but the landlord's income requirements actually made it impossible for the tenant to rent. And we resolved that case once we explained to the landlord that their practices could be considered discriminatory. They've now adjusted their policy to require that a Section 8 tenant prove that they have 2.5 times the portion of that they pay of the rent. So the way that a voucher works is typically a tenant pays 30% of their income and the voucher makes up the rest. So a landlord might have a requirement that the tenant show that they make 2.5 times their portion of the rent, and that way it doesn't exclude the tenant from renting, and it gives the landlord some security that the tenant is able to pay their portion of the rent. So that's one possible solution. It's up to the landlord to decide how to resolve it, but their policies can't be discriminatory.
I just want to ask on her part that you just explained. The voucher, it comes down to the voucher amount. If the landlord's saying, I'm going to charge $3,000, but the voucher's only $1,900, are you saying all the landlords are required to take it, or if they don't, advertise, we're not taking it, and saying, well, I don't want it, so what's the purview of it?
So the question is what if the rent, I think, is higher than the amount of the voucher, greater than, and the landlord isn't required to lower the rent to meet the voucher, but let's say a voucher amount for a one bedroom is $1,930 a month, which I think is the current standard for this area. And so if the landlord advertises a unit for $1,930 a month, then the landlord has to take that voucher as payment. If the landlord determines that the market value of that unit is $3,000, then no, they're not required to rent it to a tenant with a voucher for $1,930, because the landlord is allowed to rent a vacant unit at what they consider market rate. If the landlord prices the unit higher than what the market will bear, then the landlord, I imagine, would find out that that's not going to work either. So. But the landlord gets to determine the rent. If the rent is equal to the amount of the voucher, then the landlord has to take it.
And what happens to the tenant? You just are forced to wait for a landlord to just say $1,930?
It's incumbent on voucher holders to. The question is what happens to a tenant that has a voucher and if they can't find a unit that's equal to that? And the answer is that it takes a lot of footwork in our experience on the part of tenants to find, but in our experience, there are units that are priced at amounts equal to the vouchers. So we do see people, our office has successfully resolved more than a dozen Section 8 discrimination cases where the tenants were able to either rent a unit or use the voucher to pay rent on a unit where they already lived. So it's definitely happening. We've had a lot of success with enforcement of this and with helping people to use their vouchers to find housing.
Okay. Yes.
Yes, sir. I believe that last comment is in direct violation of the DRE and state law that requires housing providers to have a published requirement for housing credit score and income compared to rent. So your comment is now, I think, a direct violation of state law, because I'm required as a broker to have it published on my website, 650 or better credit, 3 times monthly income, but you sit here and say it can be lowered. That opens my office up to discrimination cases across the board, which is a violation of 64 and 67 Civil Rights Act. So now I'm confused. On one hand, we can't lower it. On the other hand, you want us to lower it, and then we get sued for discrimination. I'm just a little confused. Maybe I can get some guidance from you, sir.
Okay, Mr. Cronovet. So the comment was about having clear and fair rules for tenant selection,
Yes, sir.
for having tenant selection, whether it's credit score, income, and things
Correct.
like that,
Published.
and that brokers and managers and owners can get in trouble if they deviate from those rules and possibly discriminate against people. And it is a valid question. What we were talking about a moment ago was income requirements that may have the effect of preventing Section 8 voucher holders from renting and have the effect of discriminating against them. The source of income is now another area of discrimination you need to be concerned about. There is not a simple, easy answer, as I'm sure you recognize, that it is true. The reason why we have the published clear rules is because in the past there's been a lot of discrimination against different groups for different reasons, by realtors, by landlords, by managers, and so it's very important to have clear and fair and consistent rules. Source of income is a difficult area because by definition, these are going to tend to be people who have less ability to meet a 2.5 or 3 times income requirement, may not have the credit scores, and so on. But all we're saying today is that not discriminating against source of income is a new concern you need to take into account. And if you have a rule that might have the effect of prohibiting any Section 8 voucher because nobody has the 2.5 times the income, it's something you need to be concerned about because it may have the effect of discriminating. So there's not a simple and easy answer, and you probably want to consult with an attorney about how best to comply with that.
So the Civil Rights Code of 64 and 67 doesn't come into play because we're not allowed to look at anything except the financials. So where's the housing provider?
No, we're not saying you're not allowed to look. We're saying if you have an applicant who happens to have a Section 8 voucher and wants to use it and says, hey, I don't meet your requirement for this reason,
That's that.
you need to take that into account.
How can we do that when other people have been denied when they don't qualify 3 times?
Well,
Are we gonna
it,
end up in a
like I
lawsuit?
say, it's a fair question. It's a fair question. We don't have a simple answer.
Okay, sir, I apologize. I just,
No, there's nothing to apologize. I say it's a
you
it's
know,
a it's a good question.
Housing providers find us in a box very often. We're just trying to work with the consumer. By the way, speaking of consumer, are there any protections for the landlord or landlady housing provider in the code? Or are we always designed to hire private attorneys? And
So
deal
the
with
question
government?
is, question we've been hearing for 25 years on a regular basis is, what about landlords? Is there, landlords are being harassed, excuse me,
Yes, sir.
landlords are being harassed and what protections are there for landlords? And there's several answers to that you know because you've heard them before. But one answer is that the relationship of landlord and tenant is not an exact equal relationship. The landlord owns the property. The landlord has the potential to evict a tenant for certain grounds. And the short answer to what a landlord's recourse is, if a tenant is acting in an illegal way or breaking the lease, is to evict them. And landlord has the ability to get legal advice more readily. But I know that was mainly a rhetorical question. So we have time for a few more. Any other questions? Yes, sir.
I have a couple of questions. One, what is the mechanism in the law, maybe there is no mechanism, but for tenants that are being harassed by other tenants? You know, I can cite like 50 examples.
Okay.
Occurring over and
yeah.
over and over.
That's a very good question. What does a tenant do when they're being harassed by another tenant?
One example is we have a tenant with a gun. He threatens another tenant. We have another example. We have an overflowed tub. And the reason it's overflowed is because the woman falls asleep in her tub. Allows it to overflow.
Okay, so a couple examples. Excuse me. I want to address your question. So a couple examples. One is there's another tenant with a gun that's threatening people. Another is there's a tenant who falls asleep in the bath and the bathtub overflows. Both sound like pretty dangerous situations. So the first thing we always tell people is if there's some kind of danger and a crime's being committed, you call 911. Okay, if someone is threatening somebody with a gun, you report that to the police. That's potentially a crime. But if you're a tenant and you're being harassed by another tenant, as you say, you know, there's there's a number of different ways that could go depending on who the people are. You know, there's everything from mediation services that are available, that are great services at the county and state level, if both parties want to do it and want to actually work it out. If there's not a crime being committed where you can call the police, it's something that you could report to the property owner if you think someone is you know, breaking the law or breaking their lease. But that's very difficult. And you know, there's definitely no easy one-stop answer for how to deal with a problem neighbor. It's as old as time, you know. So as far as what we do here, I'm sure you've been told by city staff that we can't get involved in disputes from one tenant against another unless it may be a crime, or it may be, you know, maybe if they're doing something on behalf of the owner, if it's a resident manager or something like that, that's different.
I am the owner, that's my point. I have tenants that complain of being
Right.
harassed by other tenants.
Okay, he says he's the owner and he wants to know what to do when tenants complain about other tenants. Yeah, and I guess the short answer is if you're the owner and there's a complaint against one of your tenants, presumably you would want to address that and communicate with the person and try to fix it.
Step in.
Sorry?
I'd love to see the city step in.
You would love to see the city step in.
My last complaint to the city attorney's office, it was after I had a whole raft of letters from tenants saying that a single guy was chasing after them when they went to do their laundry and bothering them and molesting them. I went to the city attorney, went to the police, and they said, you could be accused of discriminating against mentally ill people. And so after that, I gave up talking to the city attorney.
Okay, well, he's saying he had a problem with the complaints of very serious misconduct by a tenant and was told that he couldn't do anything about it. That doesn't quite sound right to me, but if you have complaints about criminal type behavior, as the owner, you have not only the ability to call the police, but also to take legal action against your tenant. That's the short answer. Yes, sir.
Yeah, I guess related to that, what would be the path for evicting a very difficult tenant? You need to get a police report, like, what would that look like, or is it not possible?
Well, the question is, what's the path, the legal path for evicting a problem tenant? And, well, I mean, there's all kinds of information about that. We have an apartment association that's represented here today, and you know, there's legal steps that are pretty well known that landlords can take for illegal behavior. The gentleman sitting to your left will be happy to give you some ideas. Anybody else?
Call Dennis Block.
Yes, sir.
Regarding the car charger issue, I'm an electrical contractor, and it's a very gray area as to how things are supposed to be done. You've got building safety, you've got Edison, you've got the landlord, and you've got the tenant. There is no set way as to proceed with installing a car charger, and it gets expensive and it can get complicated based on metering. Is there some kind of information packet that can be given to all four of those concerned people as to what is expected of the installation?
Okay, it's a very good question about the installation of electrical car chargers, which, as you say, it's complicated. You have multiple parties involved, and he's asking if there's some kind of standard information that can be given out.
Senate Bill 638, just download it and read it and hand it out.
Okay, Armando just suggested to me, sir, that you talk to the Building and Safety Department.
I'm sorry, I couldn't hear it.
Yeah. The suggestion is talk to the Building and Safety Department of the city. They're the best department to give you information on that, but it's a good question.
What was the form number?
What was the form number spoken to about?
That's the bill.
State bill?
State bill 638.
And that has to do with car chargers and?
It was the recent amendments to the.
Okay, so we have some more information. A Senate Bill 638 relating to car chargers. Apparently there's some information available to the public that could be helpful on that. Okay. Yes, ma'am.
This concerns violations by the landlord of taking pictures inside somebody's apartment with them in their permission and working after late hours. And the people who are directly concerned are afraid of the hostility that will be gendered by doing anything about this. And there have been landlord
You asked a few different things. You were talking about owners and or workers going into units, taking pictures, maybe working off hours, and then you also asked about owners claiming that tenants don't really live there and they should get to raise the rent. So which one do we want to go first? I mean, the short answer on entering a unit, there's only limited ways that a landlord can ever enter your unit, right? Necessary repairs, agreed repairs, emergency, and a couple other narrow scenarios. So if an owner or their worker is in your unit legally, but then they start taking pictures and going beyond the scope of why they're there, that's illegal. That's in the code. Okay, we amended the law a few years ago to cover that sort of privacy situation of taking pictures and things like that. So that's the short answer, is that that's not allowed. Yeah, it all depends on the facts.
You would have to go to court, and you would have to sue them for doing that?
Well, she's asking, do you have to go to court? No, I mean, if you have reason to believe or evidence that workers are snooping around, taking pictures in rooms they're not supposed to be in, or things that don't have to do with the job, you can call City Hall. Yeah, you can call the code enforcement most likely, or city attorney's office. It's the kind of thing where if we can prove it, that's tenant harassment. If they're doing it to harass you. Yeah.
Are they allowed
Yes.
to take photos for appraisal? Building, like,
The question is, can they take photos for appraisal? And the answer is yes, they can. And in fact, to bring real estate agents through a unit or prospective buyers, that is one of the grounds that they are allowed to enter as well. Yes?
Regarding pictures, if landlord goes through the correct process of unit inspection and is doing the unit inspections, are landlord allowed to take pictures of the unit for the purpose of unit inspection?
The question is, as part of unit inspections, can an owner take pictures? And my understanding is there's really not such thing as a unit inspection. I mean, they're done, and if it's as part of, let's say when the property's sold, or the walkthrough for a security deposit, or things like that, there are certain scenarios where you have inspection. Well, repair and maintenance, certainly. If you're there to check the, smoke alarms, or replace, right, to do legally required things, and if the photos are legitimately related to that, you're probably okay. The problem comes when those are used as a pretext to get in there and see, oh, you have a pet, oh, you're violating these other things and taking pictures. That's not allowed.
What,
Yeah.
what if during the course of a normal maintenance issue that's been asked and being handled, a maintenance person runs into a hoarding situation? Are you allowed to take pictures of the documents of hoarding?
The question is, what if you run into a hoarding situation? Well, a hoarding situation may or may not violate the lease. The person may or may not need help, but by the same token, that is sometimes used as a pretext to invade somebody's privacy, and hoarding is a technical term that I think is maybe overused. Did you want to add something on that?
Just specific to your question about hoarding or excessive possessions, that's been added, that's considered a disability now. And so a tenant, landlords aren't supposed to be the housekeeping police, and there's sort of different standards of how much stuff is too much stuff. So if there's an objective health or safety issue, like say there is vermin, or if there's a lot of pretty clear standards about what's okay. There has to be pathways through the home. You have to be able to access all the doors and windows in the bathroom and the kitchen, and there can't be any safety hazards or health hazards. But other than that, it's not necessarily up to the landlord. If none of those conditions are present, it's not up to the landlord to determine how clean the tenant's house is supposed to be. If you do find that there are, objective health or safety issues, the landlord would need to give the tenant a notice to change those conditions. And because excessive accumulation is related to a disability now, if the tenant needed more time to resolve that issue, then you would have to give the tenant more time if they had the right documentation. This falls under fair housing law, which our office, the Consumer Protection Division at the City Attorney's Office, does a fair amount of fair housing issues. So you're welcome to call us if you have a specific situation, and we will try to help you get through it.
There's two additional sources to that answer. LA County Health Department, I had a case where I called Health Department, and they met me at the site. We met with the tenant. They gave him a month or two. He cleaned up everything, and everything was fine. We worked with him to deal with that. The second was another case where we called Jason at the fire department on the safety, the fire safety, and the things had to be moved and arranged from a fire safety, have the so-called fire department and county health.
This is a very good point he makes, that when you do have genuine health concerns, hazards going on, the health department, LA County Health, and the fire department, City of Santa Monica, can both be helpful in helping to get out there and get it resolved and get the tenants to respond. Yes, ma'am.
There's a sprinkler right above my oven, and even the code enforcement officer of the fire department said it has to be moved. What if I'm using my oven at 450 degrees for 1 hour? I'm afraid that the sprinkler might go off. And besides, the landlord, the manager came and deliberately put a lint in the sprinkler before, and the fire department code enforcement officer said it would cause fire. Of course, I have no witness, so I cannot just blame him. But what can I do about that situation? It has to be moved, and yet the management said there's no violation, and fire department said there's no violation because it is pre-existing. It's pre-existing. So what can I do to have that repaired?
Okay, the question is, she has a sprinkler that's located right above the oven that creates a hazard, and she's worried about it, and the owner says that they're not going to fix that.
The short answer to that, ma'am, is if it's a violation, it needs to be corrected. So you can contact either the fire department code enforcement or our office in code enforcement to see if it in fact is a violation. Yeah.
Any other questions? Yes.
Yes, my landlords are getting old, and I'm afraid I will have to, they might sell the building to people who want to own it. So I read on a lot of papers that the city can help me to be relocated. So
The question is, the owners are getting older, you think they may sell the property. When a new owner comes on, can you get relocated? Is that the question? No, there's a new owner is not a ground for getting relocated. You could certainly always talk to the owners about possible proposal you might have, but the law doesn't require, when a new owner comes on, they have the burden to follow the law, to observe rent control, to give notice of where you pay your rent. So there's a lot of things the new owners do, and you know, in our experience, there's a lot of our biggest problems come from new owners, especially corporations, investors who come and may have a desire to get tenants out.
yes.
But there is not a right to be relocated just because there's a new owner.
Yes, yes, but let's say that I agree to, I mean, they want to redo the building and rent it at the market rate. So I have to move. So can the city in this case help the tenants to be relocated?
Well, the question is if the new owners want to come in and rent at market rates, and the part that I think we're missing here is they can't make you leave. If you want to stay in your apartment, that's what the rent control law is all about. That's what just cause eviction is about, even for the non-rent controlled units. So if you're in a multi-unit building, they can't just make you leave. And if they try to just make you leave, you should call us.
Even if they want to redo everything? And
Absolutely. She's asking even if they do all the construction. And yes, that's why Armando's group has gotten so big and so busy, is because there's a lot of construction that goes on by the new owners, and it can be very disrupting. But if the units are affected to where they don't have plumbing or electricity for a certain period of time, or they're not habitable, then you do get relocated, but you still get to come back. But please call City Hall if you're having problems with that. That's what we're here for. Okay. Anybody else? Yes, this gentleman first.
If we rent a unit to a Section 8 tenant, any future tenant needs to be Section 8?
The question is, if there's a Section 8 tenant, does every future tenant have to be Section 8? I don't believe so. No, it's tenant specific.
Only 1 year.
Oh, it's
If it changes
only
within the
for
first
1 year.
Then you do have to go
Okay.
for 1 year with us.
So this is, the guy should be up here. Within the first year of the Section 8 relationship with that tenant, I guess, if that tenant moves out, the new occupant has to be under the program. But after that, no, it doesn't go with the unit, it's with the person. Okay, and now you, sir.
Regarding the rent control board staff on the garages as to retrofit. Approximately a year ago, the rent board unanimously voted there will be no decreases for loss of parking or loss of garage use during the retrofit process. Does staff have that clear when they get phone calls from the tenants, as happened to me last night, when they called me and I explained, I mean, I can handle it, but if they call the rent board, does staff clear that that there will be no decreases for loss of garage use and parking?
Okay, so the question is the mandated seismic retrofitting and the effect it has with something of the removal of the garages, or the tenants no longer can use the garages. Can the tenant petition for a rent decrease? The hard and fast answer is no, they cannot petition for a rent decrease unless there's extenuating circumstances. And we did have one where the owners, they informed the tenants to remove all their items and they could no longer use the garage, but they didn't start the work until 4 or 5 months later. So the tenant was allowed to petition for, I think it was a construction-related decrease, but that's in that limited circumstance. In a normal situation, no, because we know that this is a city mandated and the owners have to do it.
And staff knows.
Staff knows.
Thanks, Karen. Yes.
I'd like to say a situation and get your feedback on it, whoever is the appropriate group on it. A landlord puts a notice on a tenant's door, but puts the notice for entry before the time the notice is put on the door. Then comes in 3 days later, like 5 days after the notice has been even put on the door, saying that, well, they put a notice on the door to enter. What's the situation with that?
Okay, the question is, an owner posts a notice on the door for saying they're going to enter. The date is in the past, and then several days after that, they come in. Okay, we've had a lot of problems with notices over the years, and you know, the basic rule is that an owner, we talked about, there's only a few ways they can even enter a unit, but there also has to be reasonable notice, advance notice before an owner comes in. It's typically that's considered 24 hours or more. So if an owner puts a retroactive time, right away you've got a problem and a possible violation. And if they come in later saying, oh, I gave you notice, I get to come in, that could also be a problem. Now keep in mind that in terms of what we do of policing the harassment law, that's where this is done intentionally to harass the tenant, which happens a fair amount. It definitely happens. If it's an honest mistake, if there's a typo, if the owner meant in good faith to put a different date and they are there for a legitimate reason, then it's a different story. And hopefully, you know, calmer heads will prevail. But I think it really depends a lot on the motivation of the landlord and more about the facts. So every situation's different, but luckily we have some pretty clear rules under state law that they have to follow that we can keep an eye on. Yes.
This is a general question pertaining to apartment construction. Our building first went through mediation, took roughly a year, and then we went to hearings. We went through 22 hearings. If a decrease is determined by the hearing officer, does it revert to the beginning of the hearings, or does it revert to the beginning of the mediation?
Okay, the question is about a rent decrease petition and what does it go retroactive to? My understanding is they're not retroactive at all, but Karen, maybe you can, construction is, so maybe you can fill us in.
So with construction, if you file a construction decrease, it goes back to the date when the construction is occurring, or when, you know, the issue of the construction is going on longer than normal. So it's going to go back retro. It's different from when the rent decrease, where a new decrease amendments or new regulations, where now the decrease goes back to when the decrease is filed, or the first rent payment after the decrease is filed. So, and I just want to remind people that we do have a decrease petition, so if you need to get your carpet replaced or painting, we do have that for rent-controlled units.
The important aspect of the question is, does it revert, construction had been going on when we went through mediation.
Right.
Does it revert to before mediation or just before hearings began?
It reverts before the mediation, I believe. But again, you can call the office and we can go through it, because I know it's kind of detailed with these construction decrees, because I know you've been going through a long period with your construction decrease. But just call the office and we can just specifically address your issue with the construction decrease.
Yes, Michael.
For Ms. Kavanaugh, thank you for your excellent presentation on 1482. But I missed something, and I apologize. Duplexes owner-occupied from the inception, they're exempt. Single-family homes and condos, they're exempt. The rolling 15 years on new construction, they're exempt. I'm looking at those units in Santa Monica, California, that heretofore were exempt for new construction back in '79, going forward to Costa-Hawkins in 1995, which reiterated that all those new constructions are exempt and then exempt going forward. Those units, as you and I understand it, now fall under the statewide rent control 1482. What's your best opinion on how the rental increase, the annual increase, if any, is that going to be the new formula under 1482 for those units that have never been under rent control?
So the question had to do with units that were previously exempt from rent control, but now are covered by the state rent control law. What is the formula for increases each year? Is that something you want to tackle?
So, as you mentioned, there are units that were previously exempt from Santa Monica rent control, which now fall under the AB 1482, and the formula for increase is it can be no greater than 5% plus if the rate of inflation, which is defined by the Consumer Price Index per year, with the maximum amount being 10% per year. And those increases can be instituted two times a year, maximum of 2 times a year, but they can't exceed that cap.
Yes, I mean, thank you very much. That was my interpretation. I'm probably cheating here to ask a follow-up. On these owner-occupied triplexes, they're exempt now. Now coming under, I see them under 1482 has never been under the jurisdiction of rent control because they're exempt. I see their increases on the state formula, as you outlined the state formula.
My understanding of triplexes in Santa Monica that were exempt, granted exemption from Santa Monica rent control because they were owner-occupied, now fall under AB 1482. So they do fall under rent control, is my understanding.
Thank you.
State rent control.
Okay. Yes.
I have a question regarding HUD tenants. In the real estate business, it's disclose when you sell something. If you have a leaking roof and the buyer asks, you're supposed to tell them. Is there any responsibility or any commitment or any, what I get from housing is all they say is the tenant qualifies income-wise. That is it. They may have a whole history of construction in 3 or 4 buildings previously. And I think there's a disclosure issue that the city should tell us if we have a fire bug, we have other type of tenant that has previously been evicted multiple times.
I think your question is about what duties does an owner have when they sell?
Or when they rent.
Or when they, oh, I'm sorry, when they rent to a new tenant, what do they have to disclose about possible problems?
What does the city have to disclose?
Sorry?
What does the city have to disclose when they know that they've been evicted 5 times previously?
So the question is, what does the city have to disclose about the applicant?
The applicant.
That they've been evicted before? I'm sorry, I'm not sure I completely follow the question, but the question has to do with the situation when there's a vacancy.
I've been dealing with these people for 20 years, and they've been evicted, they've caused trouble, they've damaged property, they've done all kinds of various things.
So you're talking about chronically problem tenants who come and apply for a vacancy. Does the city have a duty to let the owner know?
On their income, but not not based on if they're gonna, I mean, a drug dealer caused a big problem, went to jail eventually, but
Well-
it caused a big problem, stayed home, went to the.
Okay, you're talking about tenants who may have other issues besides their income level, a possible criminal record or something like
The
that.
housing knows about.
That housing knows about. Yeah, I'm not sure exactly how to answer that. I mean,
They
if
have
there's-
a good faith, fair dealing between these two parties, HUD and the landlord. You can always sue at common law. You don't have to wait for a specific regulation that says HUD has an obligation or responsibility in an affirmative way to make the disclosure. The courthouse is open.
Well, right, so if I'm understanding the question, then you're wondering, is there a duty on various government agencies to report criminal behavior or other chronic problems by former tenants that may be important information to a new owner? And, you know, it's a fair question that the owner would want to know these things, but as far as legal obligations to share, nothing that I'm aware of is the short answer. And Michael and other attorneys might be, want to talk to you about representing you to pursue your rights. But no, I don't think there's a legal obligation on the government to disclose. There's all kinds of possible problems with that come to mind. Yes, ma'am.
Can someone help me understand as a tenant whether or not I should have been notified by the owner, the landlord, as to whether or not our building has met seismic, whatever it's called, regulations, qualifications, if it's safe?
So the question is, from a tenant's perspective, should the owner notify tenants that they have met seismic legal requirements? I don't know of anything
Go
offhand.
online and see if the property's on the list, number one. If it's not on the list, then it doesn't need to do anything. If it is on the list, then it does need to do it, and you can check with the city that they
It's
filed.
a good question. It's an excellent
Well,
question.
Armando is telling me that there's not a legal burden on the owner to tell all the tenants about the status, but if you're concerned that it's not up to code and that the requirements for seismic retrofitting are not being met, you should call the city, you should call code enforcement, because that's part of what they do.
And then as a follow-up, if in fact the building has to be seismically retrofitted, what happens to the tenants during the retrofitting?
Right, and the question is, what happens to the tenants during the retrofitting? And I think the short answer on relocating tenants is that if the units are not habitable, if the construction work is so serious that you're disrupted, you can't live there, then you'd be entitled to temporary relocation.
I think you did address that, thank you.
Okay, sure. Yes, sir.
I may have overheard this, but what are the things we can look for as tenants in a listing that say we're going to refuse anyone with a credit score under 700 or whatever? I'm unfamiliar with what I think I overheard earlier.
So the question is what to look for in rental ads for possible discrimination. And there are a couple of different things we talked about. Source of income discrimination, it might say something like no vouchers allowed, or tenant must pay all cash themselves, or something to that effect. But there's other kinds of discrimination where they might discriminate against families or against seniors or against people from a certain religion. There's all kinds of ways that code language is sometimes used to discourage certain people from applying or imply that an owner only wants other kinds of people. And it's really all over the place.
But I heard someone saying, that he's under certain responsibilities as an agent, I think. What are those responsibilities that might be beneficial to a tenant who's looking for an apartment?
Oh, well, okay. Well, what he was talking about was having consistent and fair, even-handed rules for screening tenants, and that you should stick with them. And he raised a valid point, which is that when it comes to source of income, some of those rules might end up discriminating against people with a voucher, such as you need this credit score, you need this income, 2.5 times income.
Did I hear that they should be published? I don't see them on listings.
Okay, well, I don't believe every rental listing has to have that, but possibly real estate brokers have if they're in the business of renting, there may be standards. I don't know. I'm not with the DRE. So yeah, no, it's okay. It's a fair question.
It would be nice to know what they're looking for published and stick to it, right?
Ask that guy afterwards, he's got the
It
information.
should be published on the broker's website as we do, so it's black and white. Thank you. Which is under the DRE, under the legislature, and under the Civil Rights Acts of 64 and 67. Serious business.
Yes, sir, in back.
If we demo a building that is rent control, the new construction becomes rent control?
The question is, if a building is under rent control and there's new construction, is it still under rent control?
Okay, so to even demo a rent control building, you're probably talking about Ellising the building. So if you Ellis the building and you build new housing or new apartments, if you rent within 5 years, it's going to be under rent control. If you rent after 5 years, it will not be under rent control. And these
So
are
the
new
first 5
accommodations.
years becomes rent control?
Excuse me?
The first 5 years becomes rent control?
The first 5 years. Yes, renting within the first 5 years of Ellising, then the building will be under rent control.
He's talking about an ADU, Adam. He's talking about they have 10 units and they slide unit number 11 with an ADU and gets a new certificate of occupancy on that one unit. Can they backdoor in to exempt it? That, just on that one unit.
So I guess the modified question is, if there's a 10-unit building and there's a new unit added, does that new unit fall under rent control? And the answer from the question is, it depends.
If it's
So-
brand new, built out, where there was just land and it's added to the land and it gets a certificate of occupancy after, then it's not subject to rent control. If it's a garage which is legally converted into a residential space, then it would be subject to rent control because it was conversion of an existing space.
Right. Okay, thank you.
Thank you, Tracy. Yes, one more question in back.
So we're still kind of confused about the Ellis. Can you explain that to us?
Yeah.
So the question is for more explanation about the Ellis Act.
Right.
So if a building is Ellis and then demolished.
Tracy, excuse me just one second.
I'm Tracy Condon. I'm the administrator of the Rent Control Agency, and it's great to see you all here. Thank you for coming out today. A lot of great information that you've all shared with us. So specifically on the Ellis demolition and building a new building, if you build the building and offer units for rent within 5 years of the date of withdrawal of the Ellis, that building will be subject to rent control for its lifetime. If you demolish a building and you don't rent the newly constructed building until 6, 7, 8 years later, that building is not subject to rent control. That's a factor of the Ellis Act itself as it was passed by the legislature. And Santa Monica's adopted regulations that mirror or that enact the state law. So is that clear? Yes?
15 years.
After 15 years, if a building was built and offered for rent more than 5 years after the Ellis, then 15 years later, it will be subject to the rent caps implemented by 1482, the new statewide rent cap bill.
Any more questions? Yes.
I forgot to say, if my landlord wants to buy my apartment, and that, it's legitimate, they are moving somebody or themselves, does the city help me to be relocated?
So the question is, if her apartment is owner occupied, does the city help her to be relocated? And the answer is yes. If the owner occupies your unit, you're entitled to permanent relocation benefits. There's a dollar amount based on the size of the unit. They have to put it in escrow, and you have to get that money when you move out. So, yes. And
But I have not put on the list to be moving.
oh, okay. Well, I'm sorry. That's a good point. Relocated can mean different things. You get money as a way of relocation benefits to help you get a new place. That is under the law. As far as help you find a new place and actually get relocated, the answer is no. There's not I mean, there are social services that can help folks who need them in different situations, but in general, tenants don't have a right to, be helped with that process, other than a pretty substantial amount of money that would help get you the move itself. Yeah, Andrea.
There is one thing, though, that if you are displaced through a no-fault eviction, that you can contact the city's housing authority, and they will put you on a list, on a short list. You kind of go to the top of the list for affordable housing opportunities. So if you do get displaced because the landlord occupies your rent-controlled unit, the landlord is required to pay you the permanent relocation benefit, which is a fixed dollar amount, as Adam said. And you should also contact the housing authority and ask to be added to there's a waiting list for affordable housing, but if you qualify, but people who are displaced and who live or work in Santa Monica are given priority on that list and should contact our housing authority.
Thank you. That's a very good point about going to the top of what can be a very long list. Yes.
On that subject, is there a timeline on the requirement when they have to pay that relocation? And if they just refuse to do it, maybe they just don't do it. Does the city have anything they can do to, or what are the city to intervene, or?
You can contact, yeah, the question is about permanent relocation when an owner refuses to pay. And, or if they just don't, they don't do what they're supposed to do, they don't escrow the money, and you contact the city attorney's office. That's part of what we do, is to make sure they follow the law. Yes?
I just wanted to ask about deed restriction, because what I thought with buildings in the past, when I went through a corporation, a housing corporation or a housing authority, I was eligible, and then all of a sudden they said the city changed its law. Now under certain guidelines, those properties are now deemed deed restricted. So I need to have an answer, because I don't know if the building has to be built before 1985, but I know that every invitation I've had the last 8 years, I get disqualified because of this so-called deed restriction or some kind of implementation of a deed restriction where it was, like the attorney had mentioned, it has to be, you have to live here already or work here, not previous residents who've been displaced a decade ago. So can someone elaborate on that?
Well, the question is about deed restrictions, and I'm not sure there's a simple answer to what you're asking about. I mean, deed restrictions come in as part of developments. For the city to allow developments, there's deed restrictions. They're entered into privately sometimes. They're sometimes the result of litigation. And I'm not sure there's anything in general we can tell you that will just answer that.
No, I'm just trying to ask is if, knowing, because I was supposed to be eligible for a unit, and then what happened is that someone said you have to go to the city housing authority, and they said, no, this is deed restricted. So I'm just trying to get an answer on when the property was built that would not consider it deed restricted, because.
Okay, so the question is there a certain year that will help you avoid the deed restrictions?
Exactly.
I just don't know. The housing authority would know about that, yes. Anybody else? Any other questions? Yes, sir.
We have a situation where a building has been purchased by a new owner, and they are trying to get rid of a son because the son has not been on the lease. The lease has been under the mother's name only. It's a 2-bedroom unit. So they're saying we don't recognize you, and they're trying to get rid of the son and evict him and get the unit. Is this something that's allowed or protected under the law?
Okay, the question is a new owner came in and is trying to get rid of a tenant because his mother is on the lease, but he's not on the lease. She no longer lives there, I assume.
She is right now in rehab.
Okay, so the mother no longer lives in the unit.
The mother, because of age, is in rehab.
Okay, so you're asking a question of landlord-tenant law, and it sounds like, I mean, in general, tenants who are on a lease of the original tenancy will have certain rights. People who are not legal tenants but have been occupants of a unit may not always have the same rights, and that is a problem that can come up with families. I don't think there's an across-the-board answer to that. It will depend on what the lease says exactly, who is mentioned, and that's one of those specific situations we probably don't want to get into too much detail here today. And I'm not sure if you're asking in an ownership capacity or as a friend of the tenants, but either way, I mean, it's it will depend on the facts and what the lease says.
I'm asking as a friend of the tenant. I'm just wondering if the tenant has been paying rent for a period of time, 4 or 5 years, does that actually establish tenancy rights?
So you're saying that the son has been paying rent?
Yeah.
Right, and if the owner has been accepting rent payments from the son, often that may create a tenancy on the part of the son, but I can't say that for sure that that's true in this situation. In general, that can happen. Did you want to add something, Karen?
Yeah, there is a case law regarding this question. It was a case law in San Francisco where the owner increased the rent on the son, and saying that he was, a subtenant. And the courts ruled that because the son grew up in the unit, he became a legal occupant. So the owner was not allowed to increase the rent or to evict the tenant. So if you want to call our office and get that case law, we can furnish that to you.
Yes, in the back.
Yes, I've noticed not only in my building but other ones that
Sorry, I can't hear her.
that are supposed to be living on the premise are not anymore because they're renting.
I'm sorry, could people be quiet? I can't hear her.
That there's supposed to be a manager living on the premise. And in our building, they've rented out his apartment, even though it's still on paper rented out, and turned it into a B&B rental. And so they've allotted one woman in the building to be there for the tenants for blood, flood, and fire. But there's other issues that come up, like there was someone spraying a leak with the rains, and we don't know who to go to now because the so-called off-site manager does not respond to calls from us, period. So who do we go to? If we have to call a plumber?
Well, a couple issues come to mind. I mean, by state regulation, any property with 16 or more units is required to have a resident manager. And resident manager doesn't just mean when there's a biblical flood or something. It means to be there as needed to manage. So if that's being violated, I'm not sure what's the best go-to agency. Okay, LA County Health. That's a great tip of the day on the manager issue. LA County Health. And it sounds like based on what you're saying, they may not really have a manager. And if that unit is being used for B&B, there may be violations of that law, which, check it out. Oh, and Karen points out you may also be eligible for a rent decrease if you don't have a manager. So that's a good way to get them to get moving on that.
Well, in theory we do, but in reality we don't.
Well, the manager has to perform managing duties, so. Any other questions?
The state law requires that your rental agreement impregnate the name of the owner or the responsible party on that, that lease agreement.
Okay. Well, thank you all very much for coming today. We appreciate it.